Hello, everyone. I am Shawna Ruetz, and I'm an attorney with Husch Blackwell's Healthcare, Life Science, and Education Group, and also a member of the Labor and Employment Practice Group. Before we begin the presentation today, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during today's program. If you have any questions during the webcast, please submit them via the question inbox. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. A PDF of the presentation is available in the program's material folder. This program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen, and a certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching. Towards the end of the program, be sure to complete your survey. We use this feedback to plan for future programs that are applicable to your business needs. So that's it for the housekeeping matters, and we'll now get started with the program. I wanted to start off by just mentioning we did update this program after we initially started advertising it. As many of you probably know, there was a recent decision that came out last week in the Ryan LLC versus FTC matter that updated what we'd be talking about today. So here is our agenda for today. We are going to first start by looking at the status of the FTC's non-compete rule. We will go over a quick high-level overview of the rule, what happened in the FTC Ryan LLC decision that came out last week. Given that decision, what's next? So the future of the FTC's non-compete rule and what employers should be thinking about now, and then potential impacts of the rule on the healthcare industry. First, we'll go over a timeline of events that have happened. You probably have heard a lot about different cases and different moving parts related to the FTC's non-compete rule. So first, the FTC issued the proposed non-compete rule back in January of 2023. In April 23rd of this year, the FTC voted on the final non-compete rule. And on that same day, the Ryan LLC filed its lawsuit in Texas. The FTC's non-compete rule was published on May 7th. And then this triggered the effective date timing, which was 120 days from when that rule went into, was published. So September 4th was the anticipated effective date of the rule. Following that, the U.S. District Court of the Northern District of Texas issued a stay in the Ryan LLC matter. So this was specific to a preliminary injunction motion, and the FTC was enjoined from enforcing its rule just specifically to the parties in that action. A couple weeks later, the U.S. District Court for the Eastern District of Pennsylvania actually held an opposite decision and found that the FTC did have authority to enforce its rule. And in that case, that was the ATS Tree Services case. And then last week on August 20th, the U.S. District Court of the Northern District of Texas issued a order in response to summary judgment motions, and this is what we'll get into in more detail today. But that order is what banned the FTC's rule and held that it would be set aside and had a nationwide effect for setting aside that rule. And then September 4th, as I mentioned, would have been the effective date for the rule, but as of right now, that has been postponed. So next we'll do a quick high level of the non-compete rule itself. So as background, about 20% of the workforce, or an estimated 30 million people are subject to non-compete agreements restricting their ability to switch jobs following their employment. The FTC's rule had a couple components. The first was a ban on new non-compete agreements, and this would apply to all workers. The second part of the rule is it also had a ban on existing non-compete agreements. So that would be non-compete agreements that were in place before the effective date of the rule, with the exception of enforcing those against senior executives. So senior executives were defined as individuals that made at least $151,164 annually, and had final authority to make policy decisions that control significant aspects of the business. So policy-making authority was final authority to make decisions that control significant aspects of the company. And to determine that level of authority, businesses need to do a fact-specific evaluation of the individual's job responsibilities. But typically, when we're talking about a senior executive that meets the definition, it's going to be C-level officers, but it does not include those that have only authority over a subsidiary or affiliate. That's not considered to be a senior executive for purposes of this rule. And also on here is reference to a written notice that was going to be required to be sent out to workers by the effective date. That was going to actually be a big part of what we were going to cover today. But with the decision with respect to the rule, putting that off, we won't go into that into too much detail. But just at a high level, the rule did require that employers provide a clear notice to workers about the ban for non-competes. And this is important in case the rule does go into effect later on. That notice could be delivered either through by hand, by mail, by email, or text message. Employers were not required to provide notice to either current workers or former workers if they did not have a record of the street address, email address, or phone number. The FTC had published a model language that could be used for that notice. And that was kind of really the area we would have focused on in this presentation about whether or not employers should use that model notice, assessing the risk of not following that notice, and creating your own notice that maybe use different language. And so that's something to keep in mind if the rule does go into effect in the future, is whether you want to use the model language or customize it to meet the needs of your specific workplace. And one last thing to keep in mind about the notice is that it does apply to current workers and then also former workers that still have a non-compete that is enforceable. So next we'll move to the Ryan LLC decision. So at just a high level again, I'm going to go over who the different parties are that were involved in this litigation. So first, Ryan LLC is a global tax service provider. They are owned and operated by over 200 principals. So each of the principal is considered a shareholder and had entered a shareholder agreement that contained a post-employment non-compete to protect the company's confidential information and business strategies. At the time Ryan LLC filed its litigation, there were a couple other litigations that were also filed shortly thereafter that were then stayed. And so the Chamber of Commerce for the USA, along with a couple other chamber groups, did intervene in the Ryan LLC case and are considered plaintiffs in that matter as well. And there were several amicus briefs that were filed in this case as well. So an amicus brief is filed when someone is not a party to a case, but has additional relevant information that they want to have heard as part of the case. So as it relates to this presentation and having a focus on healthcare, I wanted to mention the amicus brief that was filed by the American Hospital Association and the Federation of American Hospitals. So this brief on behalf of those two organizations opposed the FTC's rule, and they brought up several specific concerns related to the healthcare industry. So the first being issues of a genuine unequal bargaining power between certain employers and certain types of workers, and how this would impact the healthcare labor market, especially physicians and senior hospital executives. The rule would instantly invalidate millions of dollars of existing contracts, which would cause more problems with the healthcare labor market and scarcity, and impact underserved areas like rural communities. And another area that they focused on in this amicus brief is one of the exceptions under the FTC rules is that it did not apply to nonprofit healthcare organizations. And so this would allow nonprofit companies to continue to use non-competes where for-profit organizations would be banned from using non-competes. And so with respect to the healthcare industry, about 58% of hospitals are owned by tax-exempt nonprofits or are state or local government owned, which is another 19%. So this means about 23% of the hospitals would be impacted by the non-compete rule, where the other nonprofit hospitals would not. And so this would create a disparate treatment and produce uneven playing field among hospitals, and would have anti-competitive implications for the differences between the nonprofit and for-profit hiring and retaining employees with respect to the non-compete rule. So I thought that was just something important to highlight and to think about in the future as well. So on July 3rd of 2024, the court in the Texas case issued an order, but this first order was specific to a motion to stay based on a preliminary injunction. It granted preliminary injunction and postponed the effect of the FTC's rule, but it was specific to just the plaintiffs in that case. So following that order, the parties filed summary judgment, and the court indicated that it would rule on the merits of the case, knowing that everyone was watching this case getting close to that September 4th deadline, and had indicated that that order would come out on August 30th. So the rule instead came out a little bit earlier, came out on August 20th. And so I'm going to get just a little bit into the details of what was argued in those summary judgment motions, as I think it provides a good explanation of the challenges to the rules. But so Ryan LLC argued under the Administrative Procedures Act that the FTC had acted without statutory authority, that the non-compete rule was a product of unconstitutional exercise of power, and that the FTC's acts, findings, and conclusions were arbitrary and capricious. So the court agreed with Ryan LLC on points 1 and points 3. So we'll go over that in just a little bit more detail. So with respect to whether or not the FTC had statutory authority, the court looked into the specific wording of the Federal Trade Commission Act in Section 5, which is the power to prevent unfair methods of competition. When looking at that, the court took a look at how can the FTC enforce its powers. And the FTC has the power to enforce its rules through a hearing if it concludes that a party engaged in prohibited conduct. It can issue a cease and desist order, and then if that cease and desist order is ignored, it has the option to subject the person that violated the order to penalties. The court also looked at whether a practice is considered an unfair method of competition or an unfair and deceptive act, and said that that's typically decided on a case-by-case basis as opposed to having a one-size-fits-all rule. And then taking a look at Section 6 of the FTCA, the court looked at the powers of the FTC to have authority to make substantive rules with respect to unfair competition, and found that it did not have the authority to make substantive rules regarding unfair methods of competition. So the second area that the court looked at was whether or not the FTC's rule was arbitrary and capricious. So under the APA, a rule is arbitrary and capricious if it imposes a one-size-fits-all approach with no end date, and I'm sorry, these are reasons that it was supported in this case. So the record did not support the rule, and the FTC failed to sufficiently address alternatives. So the court found that the rule was unreasonably overbroad without a reasonable explanation. There was not a rational connection between the facts found and the choice made in the rule. The FTC had relied on a handful of studies that examined the economic effects of various state policies towards non-compete, but found that the FTC's evidence compared different state approaches to enforcing non-competes on specific factual situations, which was the opposite of what the rule was trying to put into place by having a complete ban. And the FTC also needed to consider less disruptive alternatives to a complete ban. And the court found that the record didn't do that adequately, and instead was offering conclusions about case-by-case decisions on the enforceability of non-competes. It also found that the FTC dismissed any possible alternatives and concluding that the pro-competitive justifications of the rule outweighed the harms, or that employers had other avenues to protect their interests. So in conclusion, the Ryan LLC court held that the non-compete is unlawful and must be set aside. This case was important because it was set aside and had a nationwide effect. So applying to all employers, all companies, and broader than just those involved in the Texas case. So what's next for the FTC's non-compete rule? As far as next steps for the FTC to potentially take if they want to continue to move forward with the rule being effective, the first option is an appeal to the Fifth Circuit. So the FTC has 30 days to appeal to the Fifth Circuit. At this point, they have not made any statements about whether they indicate to appeal or not appeal. And then if it was to go to the Fifth Circuit, it's anticipated that likely the Fifth Circuit would uphold the decision of the Texas District Court. And then the next step would be for the FTC to appeal that to the U.S. Supreme Court. Recently, the U.S. Supreme Court issued a decision in Loper Bright Enterprises, which overruled what is known as Chevron deference. And that empowered agencies to take certain actions. So given that recent ruling by the Supreme Court, it's thought to be unlikely that the Supreme Court would overturn the Texas rule as well. But obviously that is all up in the air to see what happens. As far as other options for the FTC, there are a couple other cases pending in other jurisdictions. So the ATS versus Tree Services case is in Pennsylvania. And a decision issued in that case actually ruled in favor of the FTC. It denied preliminary injunction and found that the FTC did have authority to enforce its rule to prevent what it considers to be an unfair method of competition. Just recently, a case out of the United States District Court for the Middle District of Florida issued a preliminary injunction against the FTC. Again, in that case, it applied only to the plaintiffs in that case. And I wanted to just read a quote from the order in that case that I thought was interesting. The court compared the FTC's actions by creating the non-compete rule as if a parent gives a babysitter a credit card and says, make sure the kids have fun while we're out. And the parent might expect the babysitter would take the kids out for ice cream, but would not expect the babysitter to take the kids on an overnight trip to Las Vegas. Likewise here, without clear congressional permission, the final rule is like the FTC's equivalent of a trip to Las Vegas and is unauthorized. So I thought that was just kind of put it in perspective of how courts are viewing the rule and those that have found that it shouldn't be upheld. And then the last option is the option that has been in place, prior to this rule. The FTC can enforce on a case-by-case basis different situations. It's thought that the FTC will probably bring enforcement actions to make example out of certain kinds of companies. So likely those that are abusing non-competes are those that are high-profile cases and that will make headlines. So what should employers do? So keep in mind, as we just talked about, there is still options for the FTC to appeal the Texas case for the rule to later come into effect. But as of what you need to do today, the September 4th compliance deadline is no longer in effect. But employers should continue to monitor legal developments. This has been changing on a weekly basis as different cases are decided. Another big piece is to audit trade secrets and confidential information. We'll go into that in more detail and what that looks like. And then also be aware of state laws on non-competes. So along the lines of preparing for a future change of this rule becoming effective, so taking steps and evaluating what steps you can take to protect your secret sauce or your trade secret and confidential information. Figure out how you can rely on other restrictive covenants. We'll talk about this in a little bit more detail later on, but along with the FTC rules, non-compete laws issued by states have started to become more restrictive. And so it is a great time to take a look at how you can use other kinds of restrictive covenants to protect your information. Develop robust training programs to build your internal talent. Expand the scope of your non-disclosure and confidentiality agreements. And create a positive workplace. And so obviously having a great culture encourages people to stay and is another way to approach retaining employees. So as I mentioned, you want to be aware of your state laws on non-competes, and you'll also want to be watching how those change. So with the FTC rule being announced, there is a chance that states may start to revise and pass laws on their own that reflect a similar ban to what we saw from the FTC. As of right now, there are already a couple states that have complete ban of non-competes. So you'll want to be aware of that, especially if you're an employer in multiple states. There are also 33 states and Washington, D.C., which restrict non-competes in some way. So whether that is a minimum income threshold, industry bans, or different limits on a scope of the non-competes. And approximately 18 states also have healthcare industry bans or restrictions. So that's something that you still want to be mindful of and make sure you're watching those. So for an audit of your trade secrets and confidential information, the first step for an audit is to evaluate what categories of protectable information that you have. So take inventory of what you have in place, what non-compete you have in place. I think it would be important to go through and identify which non-competes are for senior executives, which ones are not for senior executives, what you anticipate signing in the future. And so if you know you have certain positions that you want to enter non-competes, now might be a good time to do that. If it's something that might be banned, if the FTC rule was to go into effect later on, and having a list ready to go that identifies who has a non-compete, who's a senior executive, who's not, who would need a notice if the rule goes into effect. That just helps you prepare to respond to the requirements of the rule should it go into effect in the future. And then also consider using a combination of policies, training, security controls, and other kind of agreements to balance out your non-competes to protect your confidential information. So also look at what categories of protectable information that you have. Make sure you identify what is the most important. You can take a look at your operational and human resource policies. So do your existing policies address the needs while protecting your various categories of confidential information? This should include all your applicable policies, such as system and property access, personal use of company systems and devices, use of personal devices, and social media policies. And as you're doing this review, you might also want to be looking at whether or not your policies meet the National Labor Relations Act requirements, as those have also been changing over the last couple years. Take a look at your cybersecurity policies. Do your physical and logistical security protocols and processes address the different categories of confidential information? Or is there room for improvement or addressing things that haven't been addressed, using or redesigning the tools that you use for cybersecurity, onboarding and offboarding protocols? So do you have policies in place to protect information when employees are exiting the company? Also, take a look at your interactions with labor competitors and antitrust considerations. So you'll want to look at what interactions does your company have with other competitors for labor. This could be information sharing or benchmarking, contracts with those competitors. Those all can be interpreted as no poach agreements. So antitrust agencies have been targeting industry information sharing arrangements and alleged no poaching agreements. And so it's important to take a look at what kind of interactions and contracts you might have in place with those labor competitors. And you also want to ensure that your employees understand antitrust compliance. So that might be training to ensure that employees understand the requirements, possibly doing required mandatory training about that. So also thinking about different types of restrictive covenants that you can emphasize on instead of just non-competes. So the first area is emphasizing and training employees on what your trade secrets are in the healthcare space, looking at your rules and requirements and policies around HIPAA and patient health information, the use of confidentiality and non-disclosure agreements. And this is a big one, especially as I mentioned, with many states putting bans in place, moving towards protecting your confidentiality is something that is being upheld consistently with courts, and really a great way for you to protect your information and know that there won't be challenges to that. So confidentiality agreements, they protect sensitive information from being disclosed from unauthorized parties. Typically, that's going to apply while you're an employee and then following your employment indefinitely. Most states will uphold enforcing that indefinitely. A next option is looking at non-solicitation of employees. So having restrictive covenants that prevent employees when they leave the organization from soliciting employees of the company for a year to 2 years is a great way to have some additional protections. Non-solicitation of patients, residents, members, customers. So again, that's another restrictive covenant that you can put in place and use non-solicitations. The non-solicitation of customers is usually scrutinized a little bit higher than a non-solicitation of employees. So when you're creating your non-solicitation of customers, you want to look at who does the employee work with, what area are they working in, and customize the non-solicitation to those customers the person interacts with. Typically, they will have a set time limit. Usually 6 months to 2 years following employment is typical. And also looking at your non-competition restrictive covenants and evaluating, have you narrowly tailored them so that they do meet requirements of state laws and state enforcements. So you're looking at, the geographic scope. Does the limitation make sense? So are you limiting someone from competing within the whole United States, or just the area that they work in, a specific city or state? Again, tailoring the time of the restriction. So does 6 months make sense? Does 1 to 2 years make sense? That's where really looking at what your state laws allow will be helpful in making those decisions. So potential impact on the healthcare industry. So as I mentioned earlier, with respect to the amicus briefs that were filed in the Ryan LLC case, it is important to be thinking about that distinction of non-competes being allowed for nonprofits, but not being allowed for for-profit organizations, and the disparate treatment this can produce, how that's going to affect your labor market with hiring and retaining employees, and think about how you want to address that moving forward and how you can address it with some of these other options and policies that we talked about, and different restrictions on non-solicitation or confidentiality restrictions that you can use instead. So I actually went through this information pretty fast. So that is it for the presentation. I will go through and respond to any of the questions that have come through. And if you have any questions, please let me know. And let me also just apologize. I was going to give you some closing information. But if you have any additional questions, please go ahead and feel free to send them through. And again, we just recommend that you continue to monitor things as there continues to be changes with the implications of these rules. Thank you.